Elizabeth of York was Queen of England as the wife of Henry VII and the progenitor of the Tudor dynasty. But was she possibly even more than that? And without knowing it herself, could she, in fact, have been the first true Queen of England in a legal sense if we exclude Empress Matilda for the purposes of this question? Even the Tudor lawyer Sir Edward Coke assumed in the middle of the 16th century that Elizabeth was actually the rightful queen until 1485. The truth of this assumption depends less on the de facto king, Richard III, than on the fate of Elizabeth's brothers, the princes in the Tower. Welcome back to Lemmy History. I recently published a video addressing Richard's usurpation in a legal context. Some viewers were surprised that the daughters of Edward IV were also included in the line of succession. I therefore thought it worthwhile to examine this question again in detail in a special video. The focus is on Elizabeth of York as the eldest daughter, though what I say would also apply to Cecily and the other girls if Elizabeth had died. In England, the right of inheritance was generally governed by common law. In the 18th century, Sir William Blackstone wrote legal commentaries on the application of common law in relation to the Crown during the Middle Ages, which are crucial to our understanding of these events. Fortunately, he discussed the case of Elizabeth of York as an illustrative example. On the question of female succession, he wrote, "As in them, the preference of males to females and the right of primogeniture among the males are strictly adhered to. Thus, Edward V succeeded to the crown in preference to Richard, his younger brother, and Elizabeth, his elder sister. Like them, on failure of the male line, it descends to the issue female. According to the ancient British custom remarked by Tacitus, they are accustomed to wage war under the conduct of women and not to consider sex in the government of their empire. However, there is a central limitation. The right of inheritance must be confirmed by law." Let us allow Blackstone to explain this as well. The doctrine of hereditary right does by no means imply an indefeasible right to the throne. No man will, I think, assert this, that has considered our laws, constitution, and history without prejudice and with any degree of attention. It is unquestionably in the breast of the supreme legislative authority of this kingdom, the King and both Houses of Parliament, to defeat his hereditary right, and by particular entails, limitations, and provisions, to exclude the immediate heir and vest the inheritance in anyone else. It is therefore necessary that this power should be lodged somewhere. And yet, the inheritance and regal dignity would be very precarious indeed if this power were expressly and avowedly lodged in the hands of the subject only, to be exerted whenever prejudice, caprice, or discontent should happen to take the lead. Consequently, it can nowhere be so properly lodged as in the two Houses of Parliament by and with the consent of the reigning king. Blackstone also explains the principle of so-called devolution, which is highly relevant to our question. However the crown may be limited or transferred, it still retains its descendable quality and becomes hereditary in the wearer of it. And hence in our laws, the king is said never to die in his political capacity, though, in common with other men, he is subject to mortality in his natural, because immediately upon the natural death of Henry, William, or Edward, the king survives in his successor, and the right of the crown vests, eo instanti, instantly, upon his heir, either the heres natus, natural heir, if the course of descent remains unimpeached, or the heres factus, appointed heir, if the inheritance be under any particular settlement, so that there can be no interregnum. Specifically regarding the case of the princes in the Tower and Elizabeth of York, the lawyer also states, Edward IV left 2 sons and a daughter, the eldest of which sons, King Edward V, enjoyed the regal dignity for a very short time, and was then deposed by Richard, his unnatural uncle, who immediately usurped the royal dignity, having previously insinuated to the populace a suspicion of bastardy in the children of Edward IV to make a show of some hereditary title, after which he is generally believed to have murdered his two nephews, upon whose death the right of the crown devolved to their sister Elizabeth. Blackstone mentions only one of Edward's daughters. I suspect this was because he wished to keep his remarks simple. Nevertheless, this is, of course, incorrect. Still, we should focus on the essence of his statement. If the princes died in the Tower, Elizabeth automatically became queen, unless Parliament and the reigning king determined otherwise. We know that this situation was addressed by Titulus Regius. Legally, Richard was indeed the king, and the law had retroactive effect. However, Titulus Regius was not only repealed in 1485, but annulled retroactively. I understand that this topic may seem complicated. Nevertheless, it is essential to grasp the legal reasoning behind the actions of the principal figures of 1483 to 1485. Therefore, I will address the question of whether Elizabeth of York was legally queen in several stages to make my argument easier to follow. We will begin with how Edward IV organized the succession. Then, we will examine how we know that Elizabeth was included in the line of succession. This will be followed by the legal amendments of 1484 and 1485. Finally, I will combine these points into a conclusion, showing why certain actions of Richard III and Henry VII can be interpreted more plausibly through these legal considerations. The English Parliament legalized the usurpation of Edward IV in November 1461. The wording of the act is so cleverly chosen that it may appear to reference the law of inheritance. In truth, however, it speaks of a divine judgment made manifest through Edward's military victories. In other words, Edward ruled by right of conquest. He also had himself described as the true heir, while the Lancastrian kings were retroactively declared usurpers. Yet this had no real bearing on the question of his assumption of power. As for the matter of succession, Parliament decreed that the crown should remain with him and his heirs forever. Since Edward had no children at the time, no specific name was mentioned. It is important to note that the text makes no mention of legitimacy as a requirement for inheritance. By contrast, the Act of Accord, passed only a year earlier, clearly included such qualifications. Moreover, illegitimacy was not an automatic exclusion from the right of inheritance. I include here remarks by the Ricardian historian Anne Sutton, who explains this using the example of Elizabeth of York and the papal confirmation that she was indeed her father's heiress. The link to the full blog post can be found in the description. In other words, Parliament stipulated that Edward's heirs and no one else were entitled to the crown and the title of king. From a legal standpoint, this marked the beginning of a new line, that of the House of York, originating with Edward IV, not with Richard of York. Parliament later acknowledged that Edward's father had, in fact, been the lawful king. Yet for the question of succession, the starting point was clearly Edward himself, as the phrase, "and him and his heirs," makes explicit. A specific name appears for the first time in the Parliamentary Acts of 1472 and 1473. Here it is made clear that the firstborn son, named after his father, would succeed King Edward. At the same time, he was legally granted various titles typically held by the heir to the throne. There is, however, no direct provision for what would occur if this son were to die. In 1475, before leading his army to France, Edward IV drew up a will. This document reaffirmed that his firstborn son was his heir. At the same time, it contains a remarkable passage regarding the possibility of the king's death. We will, and in the strictest manner charge our son Edward, the Prince, or such as it shall please Almighty God to ordain to be our heirs and to succeed us in the crown of England. The monarch does not name an alternative heir in the event of Prince Edward's death, but instead places this matter in God's hands. This is striking, given that Richard of Shrewsbury was already born at the time. However, child mortality was extremely high, and it was customary for children to be considered heirs only after reaching the age of 4. Richard was only 2 years old. This appears to be the most logical explanation, unless we consider that Richard of Shrewsbury was, in fact, frequently mentioned as an heir. For example, to our said son, the Duke of York, and to the male heirs of his body coming, and for default of such heirs, the remainder thereof to our right heirs. My best explanation is that Edward IV still vividly remembered what had happened to him and his brother George. His own sons were about 2 and 5 years old when he departed for France. It would have been easy for someone to use one of them as a political pawn upon the monarch's death to secure power for themselves. Therefore, in his will, the king may have intended only to confirm his eldest son's right to the throne for the present. In 1483, another will by Edward is said to have existed. If this is true, the document has since been lost. Assuming that Edward V was immediately proclaimed king upon his father's death, it is highly unlikely that the first York monarch altered the succession in any way. What is striking is that the name Elizabeth has not been mentioned so far. So how do we know that she was actually included in the line of succession? First, in 1472, Parliament officially restored all the rights that Edward IV and his heirs possessed. It is notable that the plural form heirs is used here. At this time, however, Richard of Shrewsbury had not yet been born. Accordingly, the plural can only refer to the daughters, among whom Elizabeth must be included. Secondly, it was common practice in the granting of privileges that prayers had to be offered in return for the salvation of the king, the queen, and the heir to the throne. We find such an example concerning Elizabeth of York, shortly after her birth in 1466. She was also granted an estate for the rest of her life. After the birth of Prince Edward, however, this practice changed. The heir to the throne replaced the eldest daughter. Elizabeth ceased to be mentioned by name and instead appeared only under the collective phrase "and his other children." In 1478, Richard of Shrewsbury joined Edward V in these prayers. By then, the critical first 4 years of his life had passed, and his inclusion by name in prayers for the salvation of souls can be interpreted as an indication that he was now officially considered second in the line of succession. However, this did not erase Elizabeth's claim. Let us return to Sir Edward Coke, mentioned at the beginning. It is remarkable that a Tudor lawyer openly admitted that the right to the crown had belonged to Elizabeth. As is well known, Henry VII relied on the right of conquest to legitimize his rule. Nevertheless, it was part of the Tudor narrative that he was also entitled to the crown as the Lancastrian heir. Coke further notes that there was a parliamentary act transferring the royal title to Henry. We will return to this point in a moment, but it is significant that Tudor lawyers themselves conceded that, without this parliamentary decision, Elizabeth would have been queen. In other words, in formal legal terms, Henry VII not only usurped Richard III, but also his fiancée. These statements from Tudor sources make it clear that Elizabeth must have been in the line of succession. Otherwise, it would have sufficed to note simply that she was the daughter of Edward IV. To explicitly affirm her right to the crown would have been unnecessary and far less contentious. As an interim conclusion, Elizabeth of York was the lawful heir of her brothers, should they have died before the enactment of Titulus Regius in the spring of 1484. In legal terms, she would have been the actual Queen of England until that time. The fact that Richard was proclaimed king and crowned did not alter this, for he had no Act of Parliament to support his claim. In accordance with the principle of devolution, Elizabeth of York would have become queen at the very moment the second of her brothers died. Titulus Regius was intended to remedy, or rather to nullify, this situation. It declares, therefore, at the request and by the assent of the three estates of this realm, that is to say, the lords spiritual and temporal and the commons of this land, assembled in this present Parliament, by authority of the same, it is pronounced, decreed, and declared that our said sovereign lord, the king, was, and is, the true and undoubted king of this realm of England, with all things within and beyond the same realm, united, annexed, and belonging thereto, both by right of blood and inheritance, and by lawful election, consecration, and coronation. And furthermore, at the request and by the assent and authority aforesaid, it is ordained, enacted, and established that the said crown and royal dignity of this realm and the inheritance thereof, with all things within or beyond the realm united, annexed, and now belonging thereto, shall remain and abide in the person of our said sovereign lord the king during his lifetime, and after his death in his heirs of his body, lawfully begotten. Titulus Regius thus overrode Edward IV's previous acts of succession and established a new line. This was done retroactively, dating from the proclamation of Richard III. That retroactivity is made clear by the fact that the actions of the estates were formally ratified in June 1483. This is why, incidentally, 25th June, 1483 marks the official beginning of Richard's reign, not 26th June, since on the 25th the estates offered him the crown, and he accepted it. The de jure rule of Elizabeth, or of one of her brothers, if either had still been alive, was thus subsequently annulled. Edward V officially reigned until the 25th of June, after which Richard succeeded him. However, Titulus Regius was not merely repealed by Parliament at the beginning of November 1485. It was formally annulled. The text reads, "The King, at the special request and prayer of his lords spiritual and temporal and the commons, assembled in this present Parliament, and by the authority of the same, wills that the said bill, act, and record be annulled and utterly destroyed, and that it be ordained by the same authority that the same act and record be taken out of the roll of Parliament and be cancelled and burnt and be put in perpetual oblivion." In other words, the clocks were turned back by law. Since Titulus Regius was declared legally non-existent, the crown reverted to Elizabeth of York, or to one of her brothers, should either have survived. Henry VII, however, dated the official beginning of his reign to the day before the Battle of Bosworth. This decision was later confirmed by Parliament, and thereby became law. Consequently, Elizabeth of York, or one of her brothers, was, in strict legal terms, the rightful sovereign until that very day, according to the reorganization enacted by the first Tudor Parliament. This results in the following situation. Until 25th June 1483, Edward V was both de facto and legally King of England. Until the enactment of Titulus Regius, Richard III was de facto King of England, while legally the title belonged to the eldest surviving child of Edward IV. From 22nd August 1485 onward, Henry VII was de facto king. With the statute of 7 November 1485, he decreed that he had been the lawful monarch from as early as 21st August 1485. By abolishing Titulus Regius, Henry did not legally assume the title of Richard III, but rather that of the eldest surviving child of Edward IV, most likely Elizabeth of York, regardless of the interpretation offered by Philippa Langley. I am familiar with her latest research. It is, quite frankly, nonsense. In truth, Henry usurped not only Richard III, but in legal terms, most likely his own fiancée. This, in my view, fully explains why he arranged his coronation and obtained parliamentary confirmation of his rule before repealing Titulus Regius. He wanted to secure his position beyond legal challenge. Richard's conduct also becomes clearer in this light. Only after he had made himself legally unassailable through Titulus Regius did he permit Elizabeth Woodville and her daughters to leave sanctuary. Before that, he had them kept under strict confinement within Westminster, ensuring that they could not be removed from the realm. Had Elizabeth of York left sanctuary earlier, she would have emerged as the rightful queen, a circumstance that would have posed a serious problem for Richard, especially during the Buckingham Rebellion. The rumors that Richard contemplated marrying Elizabeth take on a new significance in this context. I am not suggesting that he truly intended such a union, but that he seriously considered the idea that children from a marriage between them would possess the strongest possible claim to the throne. To me, this appears entirely plausible. What does all this mean for the princes in the Tower? The case of Elizabeth of York can be read in both directions. On the one hand, her elevated importance strongly suggests that the boys were dead, and that Richard bore responsibility. This is also my own conviction. On the other hand, Richard did not harm the girls, although they posed a considerable threat to him. Henry Tudor's eventual marriage to Elizabeth of York would bring about his downfall. Why, then, would he spare the daughters if he had not spared the sons? I think he misjudged the situation, but that remains a personal assumption, not proof of guilt. Sometimes, history reveals a dark irony. Through Titulus Regius, the daughters of Edward IV lost their inheritance rights, yet, paradoxically, the same law may well have guaranteed their safety. In summary, if the princes in the Tower were dead, Elizabeth of York was, by law, Queen of England, even if she never knew it herself. It may even have been so de facto if the princes had already died before 25th June, 1483. Titulus Regius annulled her rule, but this act was later undone by Tudor legislation. So should we count her as a true Queen of England in purely legal terms? If it was certain that the princes in the Tower had died, I would already hold that view. Yet, since we cannot say so with absolute certainty, we cannot officially include Elizabeth among England's reigning queens. Still, we should remain aware of the very real possibility that she once held that title, if only in law and only for a fleeting moment in time. As always, thanks for watching. I'm very thankful about likes and subscriptions. They really help my channel.